Hey everybody, hope you're doing well. Welcome back for another lecture on Crim 2020. This one is going to be specifically regarding legal issues, and this is going to be probably one of the more intense, and I'll explain that in just a second. And again, why do I say intense? Because this particular lecture, we're going to really focus on a lot of the court cases that kind of set the foundation for the criminal justice system for law enforcement across the board. And so when you look at particular things related like the Terry stops, which we're going to talk about, the Miranda rights, court cases that really change the dynamics of how law enforcement functions and how they work within society, we're going to go through a lot of them. Now, a lot of these cases are also in your textbook. So again, I hope you're referring back to those to get additional information, at least through the visual sense of it. But I'm going to try to give you some nuances and some details that I think are very relevant. So what we're going to focus on, we're going to focus on legal issues. We're going to focus on the foundation, the impact, and the importance of it. And then at the very conclusion, I'm going to talk a little bit about quiz one and what that's going to look like for you as you proceed into this. So let's go. So again, court cases, criminal procedure, where does it mean? What does it all relate to? Well, it's really the process in which a person is accused of a crime and then processed through the criminal justice system. So I don't know if you remember that slide I showed you where it shows the arrest, then it shows the investigation, then it shows it going to a district attorney, and the district attorney makes a determination whether it's going to be filed or not filed. That's what the criminal procedure is about. It's really about the rules that govern the rights to protect the accused. When and how are they going to be tried? Is there enough evidence to verify or to validate the need to move forward into a court case? And when you look at it, again, the Bill of Rights, the constitutional, when I talk about constitutional policing, I talk about the foundation of it. The Constitution is really founded in the Bill of Rights. When you look at those first 10 amendments of the Bill of Rights when it was created, and then you look at the remaining 17 that occurred, you give a total of, I think it's 27. All of those rights specifically relate to how someone is processed or how someone has the right not to be processed within the criminal justice system. Now, a lot of that really came about, one, through statutory laws and through procedural laws and criminal law and court cases. But the big part of all of that ends up going to the Supreme Court of the United States. And the Supreme Court of the United States really kind of sets the precedence for what's going to be done across the nation as a whole. There can be deviations in the law at a state level, but again, federal law still trumps what is to occur, how is to occur. And these cases that are instituted, again, if they are challenged or if there is court cases related to it or case law, then again, that would be something that would be handled in a superior or a Supreme Court setting. Now, an example of that and how important that Supreme Court is to the system of criminal procedures that we use in the United States, a really good example of that involves a picture of the individual you see there. His name is Earl Warren. Earl Warren basically ran the Warren Court between 1953 and 1969. Again, interesting, he was born in Los Angeles, so very close. And basically what he did, he really started what was the term of constitutional revolution. And that term is really related specifically to Earl Warren's Supreme Court, and it refers to really the transformation of the transformative changes and landmark decisions that that court case did, because there was a lot of things that changed during that period of time that are still prevalent, still important, and still part of the criminal procedures that we use today, and without question part of the criminal justice system. A lot of those laid specifically in the area of civil rights and civil liberties. And some of the key aspects, again, when you think about it, of what the Earl Warren Supreme Court did, it included things such as civil rights and racial equality. There was one case that involved Brown versus the Board of Education, which declared that racial segregation in public schools was unconstitutional. And again, that is a very, very important aspect that you think about related to the civil rights fight. And that occurred back in 1954. There was also expansions of civil liberties. Again, the Warren Court expanded the protections of the First Amendment, freedom of speech, freedom of the press, freedom of religion, and it also strengthened the rights of defendants in criminal cases. And again, one we're going to talk about here in our lecture continues to unfold is Miranda versus Arizona. That occurred back in 1966. And that really established, again, the foundation where a requirement by police to inform suspects of their rights, and it is known as the Miranda rights. And I'll show you why it's known as the Miranda rights, because human beings are involved in that process. The Warren Court also was responsible again for looking at the process or due process and equal protection again. It used due process and equal protection clauses that were known in the 14th Amendment to extend Constitution to protect individuals from unjust state actions, significant rulings that were voted on and things like that. So very, very important. And then it was also something within that state of constitutional revolution, which was known as judicial activism. And the Warren Court was often described almost as an activist, even though you look at it where it would be today and it's very different. But it was really at the time known as interpretations of the Constitution, how they could best be used to support individual rights. And again, when you look at the civil rights impacts, when you look at the Brown versus the Board of Education on equality, there was a lot of things that really brought about the constitutional revolution and also really brought about what Earl Warren did during his period and tenure within that Supreme Court. So when you think about all those things and you think about how important those are, you really start to understand the importance of what laws establish, specifically in relation to reasonable searches of persons, searches of residence, and things like that. That goes back specifically to the Constitution of the United States. If you look at the Fourth Amendment, again, the Fourth Amendment says that no home can be searched and all without proper due cause or reasons or things like that. And we're going to talk about the search and seizure. But that search and seizure also applies to seizure of a person. So when you think of use of force or if you think of something like that, that also applies to it. Now, in order to get to that search and seizure part, there has to be a reasonable suspicion. And a reasonable suspicion is basically a standard that is used in criminal procedure. And it's used to determine the legality of a police officer's decision to perform a search. And again, that search can be on a person's residence or it can be actually on a person itself. And it really sets the standard, and it came from a case, that certain information was given to a caller regarding details of an incident that occurred. When you look at the case that really said it was back in 1990, it was Alabama versus White. And in that case, an anonymous caller called Montgomery, Alabama, and police, and they said, hey, there's an individual, this woman by the name of Vanessa Rose White, and she had cocaine in her attaché case or in her car, and the caller gave certain information in detail. So the police, following that tip, they followed Rose White, and they saw her go into an apartment complex, and they pulled her over, and they asked White, hey, you know what, can you give us officers permission to search the car in the case? Police found marijuana in the case, and they arrested White. During the process at the police stations, officers also found 3 milligrams of cocaine in White's purse. So after being charged with possession of marijuana and the cocaine, White was moved to suppress evidence of the drugs again, because in trial, that motion was basically that reversed the motion, finding that the officers did not have reasonable suspicion to stop and search. That is kind of the foundation of that case that really set precedents. Now, when you think of probable cause is required in the Fourth Amendment, and that must be met before police can make an arrest. So when you think of reasonable suspicion, again, reasonable suspicion really relates to the foundation that it's a standard used to determine the legality of an officer's decision to perform a search. That's reasonable suspicion. So reasonable suspicion to stop. But probable cause is the Fourth Amendment right or the requirement found to make an arrest, to conduct an apprehension of an individual. Probable cause is this where the fact and the circumstances within officer knowledge, and they have to be reasonably trustworthy information, which means somebody has to really define and tell them what was going on. Now, an example of that, when you look at the stop and frisk, and you look at a case that occurred in 1949, was Barringer versus the U.S., and this involved alcohol transportation in Missouri and Oklahoma and things like that. And what was found in that particular court case, and that's why all of these court cases are so important, because they set the case law that we still use today. In this case, again, it was about probable cause, where the circumstances of the officer's knowledge, did they have enough, was it trustworthy enough to make this stop? And so this particular case went all the way up through the Supreme Court. It went all the way through and became a standard of case law that focused again on reasonable suspicion and probable cause. So that's how incredibly important these court cases are. They set the standard and the tone for what occurs throughout the rest of the law enforcement community. Now, reasonable suspicion. there's a number of different things there. You see legal detention, you see reasonableness of the search, you see unusual activities occurred, all of these different things. I'm going to kind of go through this step by step, and hopefully this will be some kind of clarifying discussion for you to think about in your head. So on a legal detention, really a legal detention is when a law enforcement officer temporarily stops somebody from freedom of movement. So legal detention is, it's not about, hey, can I talk to you for a minute? No, you can't, and keep on walking. Legal detention is where, hey, I need you to stop for a second. It could be a traffic stop. It could be a pedestrian stop. It could be some reason where the officer can articulate out that he has reasonable suspicion to conclude that you were involved in something that you shouldn't have been involved in, or you broke some type of law. That's where illegal detention is. It's unlike an arrest. Again, a detention is not necessarily arrest. It just requires, remember, an arrest requires probable cause. A detention is just something that allows you to stop and articulate out the possibility of criminal activity. Now, when you look at reasonable suspicion again, and I'm going to go over this a couple of times because I think it's worth talking about, but reasonable suspicion again arises when an officer can point to a specific and articulable fact that criminal activity may be occurring. So again, that would be an officer might be driving by, he sees you reach into your waistband, he knows there's high crime in the area, he knows there's been a lot of robberies, and he saw a furtive movement where you were reaching in your waistband, he saw a shiny object in that waistband, and he believes, hey, based on the description of the individuals we know are involved in crimes, based upon the actions of that person I just saw, based upon the item I saw in that person, I believe that there's a reasonable suspicion to stop. So this is really a lower standard than probable cause. I don't have enough information yet to make an arrest, but I do have enough information to make a stop. And so again, really important. Now, when you think of unusual activity, again, that's really where there is something that deviates from the norm or indicates potential criminal behavior. And again, the statement I made where somebody looked sweaty or somebody said something or saw an officer drive by and immediately turned and made a furtive movement towards their waist, that would be an aspect where it's kind of identified as a behavior that stands out and it gives a little rise to suspicion and things like that. And then there's what's known as activity related to crime. Again, that is about the activity that's related to something logically connected to some specific crime. And so you have a crime of burglary that's impacting a particular neighborhood or community. And you see an individual walking down the street who has a crowbar sticking out of his back and he's carrying a 27-inch TV down the street. That would give you enough really reasonable suspicion to make a lawful detention to determine if this individual is involved in any kind of criminal activity based upon the knowledge that you have in regards to activity in and around the area, suspect's description, practice and behaviors of a burglar that's involved in it. Now, when you think of that association, again, is that a person associated with that activity? Is there a connection with that activity? Those are the things that an officer needs to explain. Now, there's also what's known as not free to leave. Again, the suspect is detained and he's not free to go. If they attempt to leave, they can be arrested for resisting. So if you make a stop for that individual who's carrying that TV and he has that crowbar sticking out of their back, you make a stop, you tell him, hey, I need you to just hold on for a second, I got to talk to you. I'm Officer Smith. What's your name? Where you at? He says, I'm not stopping. I'm going to keep on walking. If that person keeps on walking, pushes past, if the officer can articulate out that he had reasonable suspicion to believe that criminal activity occurred and he needed to stop to conduct an investigation to ensure that, one, if this is the suspect, there's no one else being victimized, or two, if this is the suspect, to ensure that he's stopping the crime and that element of that crime, he has the right to make that detention. Now, if the individual says, no, I'm not stopping, and the officer orders, hey, yes, you are stopping, I have reasonable suspicion right now to make a stop, I'm on borderline relation to probable cause to make an arrest. If that individual does not stop, he can actually be arrested for what's known as 148 PC, which is failure to adhere to the officer's directions. And then there's other things that are talked about too, like a justification for search for weapons. Can an officer conduct a frisk search or a stop? Again, that's based upon other case law, which we're going to talk about here in a very quick second. But the thing I wanted you to really understand, again, we're going to go through these slides a little bit quicker, is how important these foundational things such as reasonable suspicion and probable cause are to actually making an arrest. Now, probable cause, when you think of that, again, that's really the standard for a lawful arrest. It really sets the facts that an officer must have, and it's based upon their training, it's based upon experience, it's based upon an opinion that they believe is fair. It's really something that is, it has to be met before law enforcement can make an arrest. It's not just a suspicion. but it's less proof than needed for a conviction. So again, the person can be stopped, he can be arrested, but that doesn't necessarily mean he's going to be convicted. That will be handled in a court of law. But what it does do, probable cause, again, basically gives you the right to make an arrest. It's more than a suspicion, but it's less than the proof needed for a conviction. And when you think of the formation of probable cause, again, it's based upon facts. It's based upon the facts of the circumstances that would lead a reasonable person, so anybody else with the same amount of training, the same amount of understanding, the same belief in the system, to be able to make that decision and say, hey, there is a high propensity based upon my training experience and knowledge of what any other officer may or may not have at this particular time that a crime has occurred. And even if you're a private person, that would be the same thing there. If you saw somebody backing out of a house, carrying a TV, coming through a window with a crowbar, you'd be able to make an assumption, hey, that doesn't look right. That looks like somebody's breaking into that house. So that's really the aspect. It really is a lawful arrest. It requires only fair probability. Fair probability is basically it's a fair probability that the person who's being arrested has committed a crime. It's really kind of the threshold for probable cause. It's lower than a conviction, again, like I said, but it's enough to have the realization that somebody is probably involved in it. And if you look at the totality of the circumstances, again, it's based upon the arrest, the detention. It must be assessed, again, considering the totality of the circumstances, which means the entire situation rather than isolated facts. So all of these things kind of are the governing points related to probable cause. So reasonable suspicion, probable cause. Now when you get into search and seizure, again, there's what's known as an exclusionary rule. And again, these cases are really kind of, again, to set the standard for what an officer can do and how they can do it. So evidence obtained in violation of the Fourth Amendment, it may be inadmissible in court. And again, how that evidence is obtained, whether it was somebody who just walked up to somebody who started searching their pockets and pulled out a bunch of cocaine from their pocket, but they really didn't have any reasonable suspicion to make that stop, or they didn't have any reasonable feelings that an individual was involved in activity. That would be an example of the exclusionary rule. Well, why did the officer even do what he did in the first place? And that's really an extension of what's known as the fruit of the poisonous tree doctrine. This doctrine really states that evidence obtained or used to secure further evidence must also be excluded. So anything that was done, if an officer just saw somebody walking down the street, they go up to them, they stop them, they search their pockets, pull out a bunch of cocaine, and they take them into the station, find out this individual is involved in some other crime of burglary, and they go do a search warrant at the house. Everything related to that would be found excluded or not, validly obtained based upon the fact that the first stop was invalid. So all the other information and items located would be considered that fruit of the poisonous tree, which means the other things that came from that were basically tainted before it even happened. Now, an example of that came in the case of Weeks versus the U.S. A suspect was arrested by officers. They entered his home without a warrant. And again, a key was shared by a neighbor in this particular fact because the neighbor had some issue with it. So again, under the Fourth Amendment, there was a verdict, and the sentence was an extent which basically said that private papers of the accused taken without a search warrant could not be used in the case against him. Because again, it wasn't consensual, it wasn't voluntary, and there was an interaction that was originally started with an invalid search in violation of the Fourth Amendment. Another case that occurred in 1961, which also said that, was Mapp versus Ohio. Now, in this case, it originated in Cleveland, Ohio, and police officers forced their way into an individual's homes. Without any proper search warrants. They believed that Mapp was harboring suspects and bombs and all kinds of different things. And what they found in a location that was way off, down in the basement, I think it was some evidence that might have related to a conviction or something. But basically, everything that they did, because they didn't have a lawful seizure and a lawful search, it was banned from federal courts. Now, that really set the decision for the Supreme Court, again, where they came in, and the United States Supreme Court ruled in a 5-3 vote in favor of Mapp, saying that the evidence seized unlawfully without a search warrant could not be used in a criminal prosecution case. And that is the establishment or the beginning of that fruit of the poisonous tree, where if the officer's actions aren't correct at the front, no matter what unfolds at the end, unless it can be articulated out in some very unique and systematic way, it will be found to be invalid. So these court cases, although they're old, although they're dated, if you ever wonder what case law, what court case law is, how it impacts it, And what are these titles with Weeks versus U.S. or Map versus Ohio or whatever they are? Realize that they're people that are involved with it. They've been either arrested or apprehended, and they are basically fighting against the case that the government brought against them. Now, when you think of the conviction rate or what happens or what occurs, another example of that was in a case that involved U.S. versus Seltzer. Now, in this particular case, it's really important because you have to think about identifying three types of police-citizen interactions. And again, this is really a foundational aspect as well, because there are three different types. There's the initial stop. The truck was stopped. They continued the detention with this individual, and they consented. A consent search was valid by the troopers as they searched through this individual's car. And then, assuming that the stop and detention were lawful, the defendants have standing to challenge the search of the truck. And those are the types. So the encounters, all three of those encounters, and the three types are citizen police encounters, which is usually a consensual encounter, which involves a citizen voluntarily cooperating with the officer saying, yeah, that's fine, go ahead and search. There's also what's known as an investigative detention or a Terry stop. And a Terry stop, again, comes from a case law, which I'm going to talk about here in a second. And that could involve a seizure that are justified only if there's articulable facts related to the reason for that stop. And we're going to talk about what could that be. So again, it could be, hey, I saw a furtive movement, or I saw an individual who I know may have been armed in the past. He's in an area where there's a lot of crime occurring. That would be an example of an investigative detention. So remember the three types: consensual encounters, investigative investigation, and then there's arrest. And that's where, again, it's highly intrusive. There's a detention. There's probable cause to make that arrest. All of those things fall into place. Walk away from this slide with these three aspects: consensual encounters, it's a voluntary interaction; investigative detention, it's a temporary detention with reasonable suspicion; and then an arrest, it is a actual arrest, taking a person into custody, and you're using probable cause. Those three forms of police detentions. Now, search and seizure, again, we talked about it, constitutional policing and the impact of it. The foundation of search and seizure relates specifically to the Fourth Amendment. The Fourth Amendment, without question, is the foundation of the United States Constitution that protects individuals' rights from unreasonable searches by the government, and it ensures that warrants have to be put into place. It is basically does not require or give a person absolute right to privacy. And what does absolutely right to privacy mean? Well, it's not guaranteed that a person has right to privacy. It protects against invasion of privacies that are deemed unreasonable, but it's really about there's no place, your home can be searched if you're involved in crime. Your business can be searched if you're involved in crime. So there is no absolute to it. It also talks about the reasonableness of the search. So the Fourth Amendment really limits government searches to those that are reasonable. It's a determination made by the courts based upon circumstances. It's about the court can look at evidence that was provided. There is reasonable suspicion that an individual was involved in activity. It's articulated out into a search warrant, and then that search warrant is enacted by the courts, and then the officers ultimately go ahead and provide the services of a search warrant. The Fourth Amendment, when you think of search and seizure, it's about the legitimate expectation of privacy which a person has. And so not all searches are unconstitutional for the Fourth Amendment, and that's not anything that should ever be implied. If somebody goes through that process that I just mentioned about getting a search warrant, or they've stopped somebody on the street and they feel that they can articulate out reasonable suspicion to search or probable cause to arrest has been made, and they arrested somebody and then they go ahead and search their clothing or their bodies, that is an example where the Fourth Amendment would apply. Now, search and seizure, again, all the different laws that apply and the things that we talked about. Again, when I talked about the three contacts in the Terry versus Ohio, that is really the stop and frisk, that aspect of one of those three components of the consensual, the arrest, and then the investigative stop. The investigative stop was really founded by Terry versus Ohio, and basically that is a stop and frisk, do not violate the Constitution under certain circumstances. And again, it's really about the officer stopped and frisked a man for a weapon they found on Terry, which is his name, and the Supreme Court ruled that this search was reasonable, and it was done as an investigatory stop based upon information that the officers had. In Arizona versus Johnson, again, this case is more relevant. It's in 2008, so it's actually in this period. An officer conducted a pat-down search of a driver and passenger during a lawful traffic stop. police need not believe that any occupant of the vehicle is involved in criminal activity. So again, when you see those passengers in cars, they're saying, hey, you can't do anything to me. I'm just a passenger. This is an individual. If the officer can articulate out there a specific court law that allows an officer to do a quick pat-down search of both the driver and a passenger in a car, if and when that is necessary. And that is Arizona, again, versus Johnson. Now, another case, again, I'm going to skip down a little bit, but it's Payton versus New York. And that is really about requires police to secure a warrant for a felony arrest in a private home unless there's extenuating circumstances are present. And I'm going to talk about extenuating circumstances here very quickly. Bottom line, all of these cases are the beginning and the end of the standards that are used by law enforcement and within the court system to validate or to verify if an officer acted properly and ethically during the conduct or the conduction of a search and seizure of a person or of a home or of a vehicle or anything else like that. And again, that Terry decision that really set the standard for reasonable suspicion, balancing the need for law enforcement to protect themselves. That's really what it was about, and also balancing the need for the public to have freedoms and rights. Same thing with the Arizona versus Johnson case. It really expanded the Terry search to enable and to include a passenger of a vehicle. So very, very important, very important. And again, the Wilson case, same thing, 2000. It really highlighted the behavior in the context of flight, and if somebody is leaving or somebody's running away to determine reasonable suspicion. So these cases, again, although they might not mean anything to you, I hope they do. I hope you take some time to study them and to go into them a little bit deeper, because each one of these set the foundation for what you are learning and what you will continue to be learning throughout your time here. Search and seizure of property. Again, when you think of search and seizure of property, you have to look at two different ways. There's a plain view doctrine. Arizona versus Hicks set that case where shots were fired into an apartment. While in the apartment they see stereo equipment that was stolen and some different things. So they basically said, hey, we have probable cause to arrest based upon the plain view we saw. We went in there for one thing, we saw another thing. The open field doctrine related to search and seizure, again, that's Oliver versus the U.S. And in that doctrine, it was about a warrantless search that occurred at a property owner's home location. And unless there was some legal base for the search, it excluded the home or any adjoining land, such as yards and things like that. But open fields do not fall under Fourth Amendment. So that's what was really found. It was an open field. It was basically abandoned property, and it allowed the search to be conducted with or without that search warrant. So these are some examples: plain view doctrine and open field doctrine. Now, continuing on with searches and seizures of property, again, there's an expectation to the search warrant requirements. And what does that mean? Again, we talked about how you have to go through courts. We talked about all the case law that set the foundation for poisonous fruit if evidence is taken without being first properly executed with a search warrant, or if there's some reason the officer can articulate out. But there are extenuating circumstances to that, or expectations, and one of those is what's known as hot pursuit. So in a hot pursuit would be, I'm chasing somebody, you're chasing somebody, you're a police officer, you see somebody with suspicious activity, furtive movements, they might have put a gun away, whatever it is that you can articulate out as reasonable suspicion. You get involved in a foot pursuit with them, you start chasing them, and they run into their house, you follow them into the house, and you arrest them. Once you're inside the house, you look around and you see a bunch of narcotics. You have the right to go into that house first off based upon your hot pursuit. You have to articulate out that there wasn't a time break or a time period in between that. And then as far as anything else that might be inside, if it's in that plain view doctrine, you have the opportunity to secure that house, see what was inside there. And if you wanted to go deeper, then that's where you would get a search warrant. So that's an example of it. Now on a vehicle search or pretextual searches, again, very important, because a pretext stop is basically something where you see a driver's license or a light that might be broken out, or on a car or something like that would say, hey, there's something about that I'm going to stop. And once you make that stop based upon a malfunction of a car or a pretext, you start through the investigation and you verify, hey, there's something more involved with this. There's something more detailed that I have to go into. And on vehicle searches, again, under automobile expectations, police can search a vehicle without a warrant if they have probable cause to believe it contains evidence of a crime. So that's really an important aspect related to those vehicle searches. and that pretext stop, again, being one of those really important things. But with that, it's important to also note that pretext stops in a lot of agencies are being taken away because they said, hey, you're just using a pretext stop to get to something bigger. You're using a minor traffic stop to get to something that goes to much more or a higher level. And is that legitimate anymore? So that's related to cars. Now, when you think of search and seizure of property, again, there's a myriad of different cases. And again, I could go on in all of these, and I'm going to do a little bit, but I'm not going to do all of them. But I do hope that you do take a look at them. But some of the ones specifically related to vehicles that I think are important, and I'm going to do the first one, which is, let's see, Indianapolis versus Edmond. And again, I think that's really an important aspect. And again, this particular court case went all the way up to the Supreme Court, and the court ruled that police checkpoints set up for the primary person of detecting illegal narcotics were unconstitutional under the Fourth Amendment. And this is really an important case because when you look at the DUI checkpoints and you look at things like that, again, those are done for a specific activity. It's not done for just trying to stop narcotics violations or checkpoints related to that. And so this case really established that police cannot use checkpoints primarily to detect evidence of ordinary criminal wrongdoing. But it also really emphasized that there's a need for clear and non-criminal purposes for checkpoints, such as preventing drunk driving and things like that. So that was all held. And then on the other one, Illinois versus Linster, again, that was really a Supreme Court case that upheld the constitutionality of police and checkpoints. And so those checkpoints and those rulings were found to be constitutional based upon how they were done and where they were done at. And each one of these court cases, again, Ross, U.S. versus Ross, another really important that talked about the probable cause to search a vehicle, where they can search parts of the vehicle and it contains that may be concealed or objects. So this case really expanded the search or the scope of automobile searches, and it allowed for more thorough searches of vehicles. And again, it goes on and on. If you look at Wyoming versus Huntington, again, another decision that extended automobile expectations and emphasized that passengers' property can also be searched. So again, remember we talked about passengers coming out of the car to get pat-downs for weapons. This also talks about passengers being searched for any type of things in and around their persons. So again, these cases are incredibly important and they're really incredibly detailed, and we would take a whole couple of classes to talk on each one to show the validity of it. But all in all, they all relate to the court process, the proceedings, the standards of what's used for present day search and seizure, modification of searches. Now, I am going to talk about warrantless searches real quick, and this is an example of Carroll versus U.S. This case was established really as the automobile exception to the Fourth Amendment, allowing law officers to search a vehicle without a warrant if they have probable cause to believe that it contains evidence of a crime. This really, again, talked about the specific inherent mobility of vehicles and reduced the expectations of privacy in vehicles compared to like a home. So that set the standard for that. Ross, again, it did the same thing. It expanded the scope of warrantless searches in vehicles, permitted through, searches and probable cause exists to believe that there's something inside of those cars. So all of these things, they really kind of started talking about searching of vehicles, the searching of passengers of those vehicles, searching of the individuals driving those vehicles, the definition of how deep you could go into a search of a vehicle. All of these case laws are what officers use today to say and articulate out, I can go into a car, I can search that car, I can get involved in it. Now, I wanted to show you this real quick because this is kind of a real-world synopsis or a scenario, and it's an acronym. It's called SPICE, and it's used to help an officer recall how a person or a place can lawfully be searched and those items seized if and when it's within the scope of the Fourth Amendment. And so first off, when you think of SPICE, again, like I said, this is used every day, but SPICE, first I want a search warrant. So do I have a search warrant? If I don't have a search warrant, do I have the remaining things to make this still a legal search? Do I have probable cause? And then you think of probable cause, it's related specifically to vehicles. Because you can have probable cause to arrest for an individual in their home, but you still can't just force your way in without a search warrant. So SPICE relates specifically to, do I have a search warrant? If I don't have a search warrant, do I have probable cause? That's for a vehicle. Remember all those cases I talked about, Ross and Illinois and all that? And then lastly, incident to arrest. I make an arrest of somebody. I search their pockets during a property search. I locate cocaine. That's another example. Consent. Did the individual say, yeah, go ahead and search my car or go ahead and search my house? I don't care. And then lastly would be that example of extenuating circumstances where you're in foot pursuit, where there's somebody screaming inside the house. You kick the door and you go inside to save somebody, and you see a bunch of stolen property or narcotics or something like that. Those are examples. So that's a really good acronym to remember. Specifically, do I have enough to conduct a lawful and ethical Fourth Amendment search? And again, it's search warrant. If not, do I have probable cause for vehicles? And if next, is it incident to arrest? Do I have consent, or is there extenuating circumstances? So that's SPICE. Now, we talked about this at the very beginning, about 30 minutes ago. I'm going to kind of finish it up now. But again, this is an example where rights in the Fourth Amendment and convictions apply not only to homes, residents, it also applies to the rights and how court cases establish the foundation for rights of an actual individual. Now, this is an example of that. And when you think of what this means, this is everybody sees this on TV, everybody gets this. This is the interrogations or confessions right. So Fifth Amendment, remember the first 10 amendments, again, it protects against an individual against self-incrimination. This is an example of that, and that case was in 1966. That talked about specifically incrimination. It was Miranda versus Arizona. And what this case did, it required police to advise a defendant of his or her rights in cases during custodial interrogations. And they have to advise the defendant of his or her rights. They have to let them know, hey, you can remain silent. You have the right to an attorney before talking. And it was really kind of the primary holding under the Fifth Amendment that any statements that a defendant in custody makes during an interrogation are admissible as evidence, and at a criminal trial only if law enforcement told the defendant of these specific rights. And so you can see why this is so incredibly important. Now, where did this Miranda warning even come from? Well, like all of these court cases, they came from an actual individual. So there was an individual, Ernesto Miranda. He was arrested in Phoenix, 1966, based on circumstantial evidence that he had been involved in a kidnapping and a rape. He confessed to the charges following a really lengthy interrogation. He signed a statement that said he was involved in it. All of this information came out. Miranda was never told of his right to remain silent or of his right to have an attorney or any of these other things. And so all this information, he objected in a written copy that the confession and the evidence of trial was all done outside of the legal process. So the objection overruled that Miranda was convicted of kidnapping and rape, at least in part because of the written confession, and he was sentenced to 20 or 30 years. An appeal process happened again, which then takes it through the appeal process, which we're going to talk about later on in the upcoming weeks when we get into courts. But this appeal was based on the confession saying that it was involuntary, and the Arizona Supreme Court found that, again, the information has to be done where an individual is given their rights, and those rights are clearly defined before they make a confession, before they talk. And so those rights, when you see all those things on TV, you have the right to remain silent. Anything you say can and will be used against you in the court of law. All of those things came through the Miranda. Now, when you think of the interrogation, the Miranda warning requirements, again, there's public safety expectations. Again, if something is an immediate threat to the public, so if someone was barricaded in a house, you're trying to talk to him to find out something, or if a bomb was going to go off, you had to get information. That would be an example where there would be a deviation to that. So again, we covered a ton of court cases. We covered so many, and I apologize for it, but that's the pace that we have to keep going on. I hope that you are taking the time and energy and the effort to go back, research on some of these court cases, because some of these, Miranda, versus Arizona, Terry versus Ohio, these are really the foundation of what law enforcement does, and you have to be very, very concise and clear with these. Because if you don't, these are the things that get law enforcement in trouble. These are the things that get individual officers in trouble. These are the things that have been found by case law to be the standard and the procedures that should be used. So, in summary, Fourth Amendment related to search and seizure, case law, the validity of all of these cases, incredibly important, incredibly something you got to have to be connected to. Please take the time and the energy, follow it. Thank you for this week. I know it went a little bit longer than expected. You have a Canvas question this week. There's also quiz 1, so make sure you take a look at that. And then lastly, just want to say thank you very much for what you guys are doing so far. Appreciate everything that I'm getting, all your Canvas responses, all your questions, and everything else. Keep up on it. Keep up the good work, and have a